Welcome to the Bare Metal Cyber CISSP Prepcast. This series helps you prepare for the ISC Squared CISSP exam with focused explanations and practical context. In this episode, we are diving into intellectual property and licensing laws, two areas that are essential for every cybersecurity professional to understand. Intellectual property, or IP, refers to creations of the mind that can have commercial or operational value. Licensing laws govern how those creations are shared, distributed, or used. As organizations continue to innovate through software, design, branding, and business methods, understanding how to protect and properly manage IP becomes crucial. Not only does this safeguard creativity and business advantage, but it also ensures that your organization avoids legal disputes, regulatory penalties, or reputational harm due to improper use or infringement. Let us begin by understanding what intellectual property is and why it matters. Intellectual property refers to intangible assets created through innovation, creativity, or unique organizational processes. These include things like inventions, original software code, branding elements such as logos and slogans, proprietary business strategies, digital media content, and research findings. Intellectual property can be just as valuable, sometimes even more valuable than physical property, particularly in technology-driven industries. There are four primary types of intellectual property protections. The first is patents. Patents protect inventions and novel processes that are useful, non-obvious, and original. They give the inventor exclusive rights to use and commercialize the innovation for a specific period of time, typically 20 years. The second is trademarks. Trademarks protect brand identities, logos, names, symbols, or slogans that distinguish a product or service in the marketplace. The third is copyrights. Copyrights protect original creative works, including books, music, software code, and digital content. Unlike patents, copyrights arise automatically when a qualifying work is created, although formal registration strengthens enforcement. The fourth is trade secrets. These are confidential business details, such as recipes, formulas, algorithms, or proprietary processes, that provide a competitive advantage if kept secure. Managing intellectual property well is about more than legal filings. It is about protecting assets that give your organization a market advantage. When properly managed, intellectual property can be licensed, sold, or used strategically to generate revenue, enter new markets, and protect innovation. Next, let us examine the risks and threats associated with intellectual property. Intellectual property can be lost, stolen, copied, or misused just like physical assets. But because it is intangible and often digital, the threats can be harder to detect and even harder to stop. Unauthorized disclosure is one of the most common risks. This could happen through careless email handling, unsecured storage, misconfigured cloud services, or accidental sharing with external parties. Infringement occurs when another party uses your intellectual property without permission. Theft involves more deliberate efforts, often through cyber attacks, espionage, or insider misuse. Counterfeiting is another major threat, where third parties create fake versions of a branded product or service, damaging your brand and confusing your customers. Cyber threats such as malware, phishing, and remote access attacks can target IP directly. Insider threats are particularly dangerous because employees or contractors may already have access to confidential information. Supply chain vulnerabilities can expose IP when third parties fail to secure shared information or misuse licensed materials. Infringements and theft can lead to litigation, fines, and even the loss of patent or copyright protections if organizations fail to act. The financial costs are significant, but so is the reputational damage. Losing control over your IP can cause customers and investors to lose confidence in your brand. That is why regular IP risk assessments are important. These assessments examine how IP is created, stored, accessed, and transmitted throughout your organization and beyond. When combined with ongoing monitoring, they help detect threats early and prevent loss or misuse. Managing these risks requires tight coordination between legal, cybersecurity, and business teams to ensure protections are in place across both technical and contractual domains. Now let us talk about licensing laws and agreements. Licensing is the formal process of granting another party permission to use your IP under defined conditions. These conditions are specified in licensing agreements. The goal of licensing is to protect the rights of the IP owner while allowing others to benefit from or incorporate the IP into their own work legally and ethically. There are many types of licenses. Software licenses may define how a program can be used, how many users are permitted, and whether modifications are allowed. Patent licenses grant permission to use patented technology, usually for a fee or royalty. Trademark licenses define how branding assets may be used by partners or affiliates. Copyright licenses allow others to use creative works under specified limitations. Licensing agreements are legal documents and must be carefully crafted. They define the scope of usage, the duration, the geographic territory, the financial terms, and the conditions under which the license can be terminated. They also typically include provisions related to dispute resolution, indemnification, and audit rights. Clear, enforceable licensing agreements prevent misunderstandings and protect both parties. If your organization uses third-party software or content, you must comply with the licensing terms. Violating a license, intentionally or accidentally, can result in lawsuits, penalties, or revocation of access to the IP. For example, using open-source code without following its license restrictions could require your company to disclose proprietary code publicly. Understanding these obligations is part of good governance and risk management. For more cyber-related content and books, please check out cyberauthor.me. Also, there are other podcasts on cybersecurity and more at baremetalcyber.com. Let us now focus on how to protect and manage your own intellectual property assets. Cybersecurity controls are a big part of this. Sensitive IP should be stored in encrypted formats, access controlled based on job roles, and tracked through audit logs. Systems that house valuable IP should be segmented from general networks, monitored for unusual activity, and protected by multi-factor authentication. Regular audits help maintain control. You should know what IP your organization owns, where it is stored, who has access, and how it is being used. If you cannot inventory and track your IP, you cannot protect it. Employee education is also key. Staff must understand what constitutes IP, why it matters, and how to handle it properly. This includes knowing when to label information as confidential, how to securely transmit files, and what not to share publicly or on social media. Internal policies should spell out expectations for IP use, storage, and disclosure. These policies need to be reviewed regularly and enforced consistently. Non-disclosure agreements, or NDAs, are another important tool. They legally bind employees, contractors, and partners to maintain the confidentiality of specific information. NDAs should be used whenever sensitive IP is shared externally or internally across organizational boundaries. Let us now talk about continuous compliance and IP risk mitigation. Intellectual property management is not a one-time effort. It must be maintained continuously. This includes periodic legal reviews of licensing agreements, internal audits of policy compliance, and updates to contracts or access rights as roles or projects change. Your incident response plan should include IP-specific procedures. What happens if trade secrets are leaked? What if a supplier is caught selling counterfeit versions of your product? Your team should know how to contain the damage, investigate the incident, notify stakeholders, and pursue enforcement. Cross-functional collaboration is essential. Legal teams ensure that contracts and agreements are airtight. Security teams monitor systems for breaches or misuse. Business units help identify what information is most valuable. Together, they develop cohesive IP protection strategies. Technology also plays a role. Monitoring tools can detect unauthorized access, detect exfiltration attempts, and flag violations of data handling rules. These alerts help organizations act before major damage occurs. Finally, a mature IP risk management program must adapt over time. Regulatory environments change, new products are launched, mergers and acquisitions shift ownership structures. The more your organization evolves, the more your IP protections must evolve with it. Post-incident reviews provide lessons. Supplier or partner feedback can offer improvements. Employee input may reveal training gaps. All of these insights contribute to stronger, more effective protections for your most valuable intellectual assets. Thank you for listening to the CISSP Prepcast by Bare Metal Cyber. Visit baremetalcyber.com for additional episodes, comprehensive CISSP study materials, and tailored certification support. Deepen your understanding of intellectual property and licensing laws, and we'll support you every step towards CISSP certification success.